Good morning. It's that time of week where you can get some free legal advice. So jump on the phone. Our talkback lawyer, David Whiting, is joining us here. G'day, David.
G'day, Paul.
How are you?
Very well, thank you.
Jon Faine's not here today.
I've noticed. You've got more hair than he's got.
Barely. And he's in the Supreme Court overseeing his niece becoming a lawyer. What is this ceremony? I've never heard of it.
When you finish your law course and you have met the requirements for entry to the profession,
yes,
you make an application to the court to be admitted as a Australian legal practitioner and an officer of the Supreme Court of Victoria.
Yep.
And that's an application that's made in a formal court setting, and there might be 30 or 35 people applying at the same time. And somebody, the technical term is moves your admission.
Oh.
So you file an application to be admitted, and John will stand up and says, if it please the court, I appear to move the admission of,
yes,
as an Australian legal practitioner and a officer of this honourable court. And
so you don't have to be a fee-paying practitioner?
I'm quite sure that John pays all these fees, Paul, but
I thought he was done with it.
Well, they said once you're admitted to practice,
Yeah.
you become what's called an Australian legal practitioner.
Yep.
Or Australian lawyer is what you are, okay? And when you have... so that's, in a sense, that's the qualification.
Yeah.
And what you then do is apply for a practicing certificate, and a practicing certificate brings with it professional education obligations and the rest of it, and you're required to have professional indemnity insurance, and you've got those. You then apply for a practicing certificate. So John's an Australian lawyer because he met all of those requirements even though he doesn't currently practice.
Yep.
I'm a current legal practitioner because I have a practicing certificate and the insurance and the other bits and pieces.
I'm sure it's a very exciting time for those.
Oh, it's fantastic.
Mostly young
Absolutely.
people getting into the fray. And obviously, John's niece doesn't listen to any advice or his program when he says that he's glad to be on the radio instead of back in the court.
It's a completely different world.
Yeah.
It's. I'm always impressed by people who report law cases, because I've sat in court for days waiting for something to happen and it never does.
Yeah.
So,
did you have any homework from last time?
I'm homework free, but there are a couple of things that I thought I would flag. Last week there was a fair bit of press about. There was some suggestions that if you take a defendant to court and they're found guilty, that it might be appropriate to make a compensation order in favour of anyone who has suffered loss as a result of those actions.
So a criminal matter, maybe an assault?
Or an assault or damage to property.
Okay.
So, I smashed the windows on your car. Is it appropriate that there be an order that I pay some level of compensation?
Yes.
All the evidence is that less than 2% of restitution or compensation orders get paid. And I think if you made it a compulsory element of the process, it's not going to improve. In a sense, what you want are laws that people will honour and obey, rather than I'm now going to make this compensation order, which is effectively meaningless. Because
so rather than toughen up in that instance, just know the reality that whoever smashed your window probably doesn't have enough money to pay you, or just won't pay you.
Well, I think it's more statistically, I think it's more likely just doesn't have the resources to pay.
Yep.
They're not going to be able to.
And what about a case overseas in the High Court?
In 2014, the European Court of Justice ruled that irrelevant and outdated information could be removed from search engines on request. And so since it's a right to privacy, it's an extension of that. At what point does news about me or you become irrelevant? So there were a couple of applications made to the High Court, both decided by one judge. One got up, one didn't. The first one was 11, where a businessman said there were 11 publications that referred to his conviction imprisonment 10 years ago for a surveillance offence, and he's got... Google was ordered to remove the links from those articles to searches on that person, and the other person complained that Google links provided information on a conviction for conspiracy to account falsely for which he received a sentence of 4 years. So it's a dishonesty offence.
Yep.
And he was unsuccessful. That remains on the list. So,
well, a conviction like that would stay on your record anyway. But some things don't stay on your record if they're not serious enough.
It's interesting. Every jurisdiction but Victoria has a concept of a spent conviction.
Yes.
And so if you were convicted of a particular class of offence 10 years ago, 12 years ago in New South Wales, then and you were asked, do you have any priors? The answer was you wouldn't be required to disclose it. The technical answer would be no.
Yeah.
Because they're regarded as spent. They've fallen off the end of the... We, on the other hand, only have the concept of a spent conviction for a .05.
Yep.
So if a person's last conviction for a .05 was more than 10 years ago, then we'll penalise you for the first lot.
But either way, unless you're willing to go onto a big legal battlefront, people can just search you on the internet.
Well, they can. Since 2014, Google has received, just out of Europe alone, 2.4 million requests to, in a sense, stop tracking me.
Yeah, okay. So one of those cases at least got some strong precedent. Let's go to the callers now, and we'll go to Diane in Ormond. Good morning to you.
Good morning, Paul and David. I'm ringing in relation to an issue that happened with my daughter in a rental property in January. She was in the shower and received a significant electric shock and had to spend a few hours in the hospital and had immediate testing and then ongoing testing after for a week or so after the incident. As a consequence of that, my daughter and her partner moved out of the apartment because they just felt emotionally confronted by the experience.
Yes.
And as ongoing discussion with the agent has agreed to pay their bond back, but has refused to pay her medical costs because they see it as being without justification or with the consent of the landlord or reference to the agent themselves.
I think that the landlord has an obligation to provide you with safe premises. If they're not safe, you could make a claim for compensation against the landlord. Now, clearly they've failed appropriate electrical safety standards.
Yeah.
So you have your daughter has a claim for compensation and would have the ability to make a claim to VCAT to shorten the lease. That bit's already happened. You can make a claim for compensation. But whether you'd bring it in the magistrate's court, because it's really a personal injury type claim,
yes,
as opposed to a contractual claim under the residential tenancies legislation. Probably magistrate's court? Magistrate's court.
Yep. So there's no liability for them to pay her medical costs as a result of that?
No, but that's the question.
Yeah.
Your daughter's been injured. Your daughter has a claim for compensation as a result of loss she suffered,
yes,
while using some premises that she thought were safe.
Yes.
Right? So are they required to pay medical bills? They're required, I think, to pay compensation that would be assessed with that part of the compensation would be the medical bills.
Yes.
But there's no automatic right to, I've been injured while I was in your premises as a result of something wrong with the premises. You have a legislated obligation to pay medical bills. No.
Okay.
So seek out some sort of resolution through the magistrate's court there.
Okay, thank you very much.
Diane, thank you very much. Let's go to Anne now, who's in Ballarat.
Hello there, David and Paul. Thank you for taking my call. My husband is a sole trader and he fixes small engines, and sometimes people don't pay or they pay part of the payment. I wondered if you could tell me what our position is there.
Tradespeople everywhere have just sat up straight and they want this answer.
Anne's husband's in a slightly better position than most because there is a concept at law called a repairer's lien, and LIEN, and it allows a repairer to hold goods until they're paid or there are satisfactory arrangements for payment. So, and you can issue, you can do debt recovery proceedings at VCAT It's a civil claim. You could do all the paperwork for him and issue the proceedings, and that would be dealt with at the Ballarat Magistrates Court because VCAT sits there. But you also have the ability to simply say, well, I'm really very sorry, but I'm holding it till you pay.
And
what else are you looking for?
Well, I was just thinking sometimes, like, the machines take up storage space or they get in the way, and once they've been sitting for a while, they need more maintenance.
There is another process that you'll find in the Australian Consumer Law and Fair Trading Act, and it talks about the disposal of unclaimed goods. Yeah. So, and what you do depends upon the value of the goods. So there are 3 different levels, and the effort you need to go to make sure you're getting the best price varies depending upon what the goods are worth.
Okay.
So have a look at the disposal of unclaimed goods.
Yeah.
You can search for it on the internet. You can find it, if you're looking for the legislation, in the Australian Consumer Law and Fair Trading Act of Victoria.
David, and just stand by there. I've got a question for David on this one. Are there sole traders or tradespeople who are not as well positioned to reclaim money?
Well, what Anne has, as opposed to a chippy who might come and do some work on my home, is that whatever he or she has done is incorporated in my house and they can't take it back.
Yeah.
The advantage that Anne has is that he has goods of the customer and can retain those goods pending payment.
Yeah. Anne, are you pleased with that advice? Pleased enough? Your husband?
That's great. Sounds like there's a bit of work to do. I couldn't just sort of make a deal with them to sell the machine.
Oh, yes, you can. But that's I'm looking at what your rights are if you can't do a deal. So your first one is I've got a lien. What you might also do is look at your husband's terms of trade and put on his invoices or his quotes what his rights are in terms of unclaimed goods. You start the process a little bit earlier?
Yeah, I was thinking that too. Yeah, because I've noticed some people put the parts are ours until you've paid and stuff like that.
Well, that's a nice clause. I'm not sure that works anymore. In 2000, we introduced a legislation that created the Personal Property Securities Register. It's changed the rules. So that was called the Ramalpa clause. They don't work anymore, but you do have the right to hold the whole machine.
Okay. Thank you so much.
Thank you, Anne.
Thank you. Let's go to Laurie now, who's in Wheelers Hill, wants to talk about speed cameras.
Yes, hello. I wanted to talk about red light cameras in particular.
Okay, go for it.
I was recently in court challenging a red light camera, and it occurred to me that would I have the right, I know this sounds a bit crazy, would I have the right to call the speed camera to cross-examine as a witness? Now, I know that's silly and can't be done, but in law, how does that work? I mean, you have the police have a witness, which is a robot. Do I have the right to challenge the robot in court?
Yes, but you can't really put any questions to it. There are processes for making sure that the equipment has been maintained.
Yeah.
So if you were to look at the Road Safety Act and some of those regulations, there are a reference to how often they must be tested.
Okay.
There are references to the very precise identification of the red light cameras concerned.
Yeah.
So they're tested and calibrated.
Now, I am an electronics engineer myself, and I know very well that computers fail. You probably have experienced any number of times where your computer freezes up for no
I've always put
reason.
it down to operator error, Laurie, but yeah.
Okay. Well, I can assure you as an engineer, it's not always operator error.
Yes.
So am I entitled to, therefore, call for logs? Do they keep logs? Am I allowed to look at circuit diagrams and programming information?
That's a big one, isn't it? If you want to challenge it, to look at this.
Well, let's assume there's a 1,000 of those that have got all of the same programming lines and all of the same circuit boards.
Yes.
It's a percentages game.
Yeah.
We've got 1,000 of them, and do you want the error logs generally or the error logs for this machine? And let's say that we get to the point that there might be a 1 in a million chance or 1 in 500,000 chance that the machine failed
Yep.
or didn't work properly
Yep.
at the time that you went through the intersection,
Yep.
I've got to say I'm not sure I'm satisfied. You haven't created a reasonable doubt. You've created a remote possibility,
Yeah.
but not a reasonable doubt that the machine wasn't functioning properly at the time it took the picture that's of concern to you.
But you wouldn't know that until you examined examined the machine. Now, would I have the right to insist on examining the machine?
I think there's been a couple of cases on that, and the answer to that question is no. They're entitled to rely upon the accuracy of the certification and inspections that are done periodically.
So you can do that, Laurie. Now, it sounds like you're trying to get off on technicality, mate. Did you go through the red light or not?
Yes, and I did get off.
Well, congratulations, Laurie.
But I mean, doesn't this lead to the argument that we're trusting robots instead of human beings?
Yes, but do we not do that every day?
Yeah.
No. I'm very sceptical, and I don't.
Oh, well, you've got the right to challenge it in court if you want to go that.
But you don't. I mean, what you could do is try and buy one of the machines.
Yeah.
And then go through the process of analysing it line by line for code, looking at the circuit diagrams, looking for errors.
Yeah.
And but you're still going to have exactly the same problem on the day that you went through and they took your picture.
Yeah.
Can you create a reasonable doubt?
Laurie,
Yeah.
we'll leave it there. Thanks very much for your call, and we've got plenty more waiting, so let's go to Elizabeth in Brunswick. Elizabeth, good morning.
Hi, Elizabeth.
Good morning. Look, I rang last week about my friend who was in a townhouse where he was getting many inspections at the beginning of this year's lease. Following your advice, David, last week he started to negotiate with the estate agents, and then later on in the week, I won't go into the details of that, but some of the things like getting lists of names of who was coming to visit, he received an email saying that his lease and the tenancy has been transferred by the owners, the landlords, into a totally new estate agency. So have you got any advice on how he should negotiate?
Exactly the same way.
Pardon?
Exactly the same way.
So he just take the advice that you gave last week, but I just, how often does this happen when someone's lease is transferred to another estate agency? It's a bigger one.
Well, periodically, the landlords simply say, I want X to manage my property instead of Y.
Okay. All right then. Yes.
Thank you.
Now, the question, Paul, was that Elizabeth has a friend who lives in a rental property, and the landlord is in the process of selling the property, and they have been open for inspections.
Yeah.
And the open for inspections are, in fact, generally, depending on how they're conducted, may be an infringement of the tenant's right to privacy because they arise under the landlord's right to inspect.
Yes.
So the landlord has the right to inspect from time to time to make sure the property's adequately maintained, but the expectation is that you'll make an appointment. And the expectation is that the tenant's entitled to know who's coming.
Yes.
Because if you think about it, the people who ought to be inspecting are the owner, any tradespeople they think they might require, and the agent who manages the tenancy, and not really anyone else. And but if you're a tenant and the landlord decides that he wants to sell the premises that you're in, then from time to time they want to traipse through with a group of people who you don't know.
Can they compel you to clean up?
What does your lease say about how tidy you're supposed to keep the place?
Well, get your jocks off the floor. Where's the line?
Or you could push them under the bed, I suppose, could you? Yeah.
Yes, you better clean up if you don't want anyone.
Well, also, presumably, if the ownership of the premises changes, you'd still like to remain the tenant.
Yes, so, that's true. There's some goodwill involved there. Let's go to John, who's got a question about airlines and personal information.
Oh, hi, good morning, David and Paul. I just got back from an overseas trip where an incident happened. One passenger and I mistook each other's check-in luggage. So in order for him to reach me to get his luggage back, he got all my personal information from the airline, my passport number, my date of birth, even my pictures. And in order to reach me, he published all the information on the website.
So you took someone's luggage by mistake?
Yes.
Yes.
And he took mine. he took mine.
But didn't
So-
that's happened to me once it happened. Someone else took our bag at Qantas at the airport, and they were fantastic. They actually rang the other passenger, and they came back.
I ran the airline as well. At the time, I didn't find the other party's information, so I stopped looking. I stopped getting their personal information. But later on, they ran. For some reason,
The privacy rules, John, will depend upon the law that applies to the airline in question.
Mm-hmm.
So if you were transiting Hong Kong, or your bag went missing in Hong Kong, then the answer is it would be Hong Kong law and Hong Kong privacy law that would apply. If it happened in London, so it would be. Look, it's going to be a mixture of questions of the airline. So if you were flying an Australian-based airline, then they would be, and you bought your ticket in Australia, your privacy would be governed by Australian rules.
No, it's the international airline.
Yeah, well, then the chances are that they will be bound by, although they might be bound by the information they collect here from you. But if you will this is the issue that arises in privacy, because you reach an agreement with an Australian company, and they say, look, you've got to be aware that we're going to send your data to another country for the purpose of doing work on it, processing it, storing it, whatever. And once your data leaves Australia, the Australian laws don't apply to the data. So if your data's gone to the Philippines or to Indonesia or to India or to somewhere else, then your data will be dealt with there according to the rules that apply to the data where it is.
Fair enough. But how about the responsibility of the individual who got the information and published online?
Well, they're not covered by the privacy principles or the privacy rules.
Right.
So I understand the complaint against the airline. My view is they handed out too much information because they don't necessarily... I wouldn't have thought... How did they know you had the bag?
Because there's two bags missing, so I guess...
The assumption was it was yours. You had it.
Yeah.
Yeah.
Okay, John, thanks very much for your call. Let's go to Harry now, who's in Shoreham and wants to talk about his driving rights. Harry.
Good morning. Thanks for taking the call.
You're welcome.
I had several spinal surgery, and as a result, I'm an OxyContin user legally, and I take a nerve suppressant. Now, my pharmacist, I've been doing it for 10 years. Now, there's a case we were discussing socially about somebody who was held for manslaughter for driving under the influence of alcohol, and the question came up as my rights, and would I, if I had an accident, be charged, if God forbid I killed the person, would I be charged for murder or manslaughter because my blood level is above the legal limit?
But there's no alcohol in OxyContin. Why would your blood level be...
No, I'm not. The alcohol thing is an example. My blood level, the drug, the OxyContin, the opiate level in my blood is above the legal limit for driving.
The question is whether or not it's a contributing factor to the accident. Right, so you could be. What happens is that you get charged with the use of the motor vehicle, and the question will be: were you at the appropriate degree of negligence? Did you recklessly cause the death of another person? Were you negligent? Whatever it.
Well, take the example of me at night hitting a motorcyclist on the side in the darkness.
Yes.
While I'm driving.
Yep.
I killed that person.
Yes.
My blood level, they'll take my blood, and they'll see that the drug, the opiate, and the nerve suppressant that I take is above the legal limit. Would I be charged for murder?
The answer, I think, Harry, is no, but I'll give you a better answer next week. And the issue of concern to me is whether or not there is an automatic presumption of negligence in the circumstances you've described. I don't think there is. But if the evidence is that the consumption of those drugs has an impact on your driving ability, then you might need to modify your driving style or hours of operation or whatever to reflect that impairment.
Harry, does it make you a worse driver? Do you feel like it impairs your ability to drive when you're on OxyContin?
I don't think so, but
Okay.
I've been on it for 10 years, and the question, I'm a flat line, as my pharmacist tried to explain to me, is that my pharmacist says I'm above their level.
Yeah.
But he said it's a flat line because I'm taking a controlled release drug. Therefore,
Harry,
my blood...
listen next week and I'll tell you.
Okay.
Thanks, Harry.
Thank you.
Be careful on the roads too. That
Indeed.
doesn't just go for Harry. David, before you go, we will be discussing again shortly the Greens' proposal to legalise the sale of cannabis. The Greens are making it a health issue. Do you think legalising cannabis would ease pressure on the courts? Question without notice.
I actually think it would create a million other problems.
Yeah.
You know, I
Legal. I'm just asking legally now. I'm not asking for opinion on whether yes or no.
So what we're going to do is we'll lose some possession charges
Yeah.
and we'll lose some trafficking charges. Well, there'll still be trafficking charges because there'll be some people who can reckon they can offer a better service than the government.
Yes.
So there'll still be trafficking. There'll be no possession charges. I would have thought that my view is that it's a mind-altering drug. That there are circumstances in which its use is warranted, but as a general recreational drug, I reckon the price to the community is simply too high, and there would be, I reckon, significantly more court cases rather than less.
Well, it's an interesting one to that argument that it would ease the pressure on the courts. We're going to speak to Greg Davies, Victims of Crime Commissioner, coming up shortly as well. David, thank you very much. It's the first time I've chatted with you in the studio, but I listen every week and I think it's an amazing service that you provide.
Thank you very much.
Thank you. David Whiting there.